Welcome to the deep dive. Today, we're cutting through some real complexity in MPEP, Chapter 1400, Correction of Patents. We're talking about what happens when you find an error in an issued patent, which is stressful enough,
Right.
but then you need to potentially fix it with multiple follow-up applications.
That's exactly it. And for you, our listener, trying to, master the fine print of patent procedure, we're zoning in on MPEP Section 1451.
Section 1451, Divisional Reissue Applications, Continuation Reissue Applications where the parent is pending.
Yeah, sounds a bit dry, maybe. But this isn't just bureaucratic shuffling. This section covers the absolute critical process for maintaining the legal lineage when you're correcting a patent.
So our mission today is really to show you how the USPTO handles this balancing act. Because you, the applicant, you need some flexibility, right?
Yeah.
To correct different parts of an invention maybe discovered at different times.
Yeah, makes sense.
But the patent office, they need absolute clarity. They have to ensure any later applications keep that, frankly, priceless benefit of the original patent date.
Yeah. Oh, absolutely. Lose that date and, well,
You've pretty much lost the game, haven't you?
it can be catastrophic. So we're diving into the rules, the continuity rules, the compliance rules that really determine if your corrected patent truly stands in the shoes of the original.
Okay, let's do it. And just before we jump in, a special thank you to Mike Shepard, the creative director who organized this entire audio series.
Yes. Thanks, Mike.
All right, so the foundation. Where does the ability to even file more than one reissue come from?
It starts with the statute, 35 U.S.C. Section 251. That's the core reissue statute.
Right.
And it explicitly says you can get multiple reissued patents for distinct and separate parts of the invention. So that's your green light, your permission slip for flexibility.
So the law allows it, but how do you do it correctly? That sounds like where Section 1451 comes in.
Precisely. The statute gives you what you can split claims or errors. Section 1451 dictates the how. If you, the applicant, file multiple reissues, the procedure demands immediate, absolutely crystal clear identification.
Identification of what specifically?
You have to explicitly state the relationship of this new application, this child application, not just to its parent reissue,
Okay.
but all the way back to the original patent number. You're essentially establishing its paperwork pedigree.
Ah, the pedigree. And this is where we hit potential landmines, I gather.
You got it. The sources we looked at really stress this crucial distinction the rule makes. It separates a true continuation or divisional reissue application.
Which maintains that original patent date benefit.
Exactly. It separates that from something else, something known, rather dangerously, as a Bauman-type continuation.
A Bauman-type continuation. Okay, that sounds ominous. Why the distinction? What is it?
This is really the heart of Section 1451. A Bauman-type continuation looks like a regular continuation. It's filed based on a reissue application, but it fundamentally breaks that chain of continuity we talked about. It doesn't properly link back under the reissue statute.
How does it break the chain? What's the mechanism?
Okay, so a true continuation reissue gets its authority from 35 U.S.C. Section 251, the specific law for reissues.
Right, the reissue statute.
A Bauman type, though, it tries to use the general continuation path, which is 35 U.S.C. Section 120. That's for regular continuations, not specifically for correcting patents via reissue.
And what's the practical effect of using Section 120 instead of Section 251 in this context?
This is the kicker. The application does not inherit the effective filing date of the original patent.
Wow.
You end up with just a standard continuation. It gets the benefit of the parent reissue application's filing date, sure, but not the critical original patent filing date.
And that original date dictates prior art, patent term.
Everything. It dictates what prior art applies, the ultimate term of the patent, and even your ability to pursue further reissues down the line. Getting this wrong is a major problem.
That seems almost like a trap. Why such a harsh consequence just for essentially mislabeling the application type if the intent was clearly to correct the patent?
Well, you have to think about the purpose of reissue. It's not just another filing mechanism. It's a very specific procedure to correct an existing legal grant, the patent. And it comes with specific requirements, like that sworn declaration of error, stating it wasn't done with deceptive intent. The USPTO can't let applicants use the standard continuation statute, Section 120, which is really for pursuing new claims, to sort of bypass those stricter reissue requirements under Section 251.
I see. So if you miss that distinction, You haven't properly invoked the corrective power of the reissue statute.
Exactly. You haven't corrected the original patent in the eyes of the law via that specific path. You've just filed a new application that might suddenly be subject to a whole bunch of new prior art because it lost the original filing date.
So that immediate identification isn't just like bureaucratic preference or red tape.
Not at all.
It's the legal shield protecting the rights tied to that original patent date.
Perfectly put. Clarity is absolutely king here. And to avoid getting caught in that Bauman confusion, MPEP Section 1451 demands explicit identification right there in the application spec itself.
Okay, practical details. Where does this identification need to go, and what's the magic language they're looking for?
The sources are very clear. Put the continuity language up front. Ideally, first sentence of the specification. You need to build that statutory bridge connecting this new child application through its parent reissue all the way back to the original patent number.
Can you give us the exact phrasing? Let's walk through it.
Sure. For a continuation reissue, you'd state something like, this application is a continuation reissue of application number. You put the parent reissue number here, which is an application for reissue of U.S. patent now. You put the original patent number here.
Very explicit, naming the relationship and the ultimate origin.
And for a divisional reissue, maybe one filed after a restriction requirement from the examiner.
Yeah.
The wording is just as precise. Something like, this is an application for reissue of U.S. patent note, original patent number, and is a divisional of application number, parent reissue number.
So these specific phrases are like signals to the examiner.
Exactly. They tell the examiner immediately, hey, this is a proper 35 U.S.C. Section 251 continuation or divisional. It keeps the original patent's effective date. It avoids any ambiguity about it being a Bauman type.
Okay. Crystal clear on the cross-referencing. But beyond that, there's a whole compliance checklist, right? Other formal requirements.
Oh, yeah. You miss these, and you're looking at rejection or, at best, significant delays.
What are the key ones?
Well, the usual stuff like correct formatting, paying the fees, but critically for reissues. A proper reissue oath or declaration.
Right, the declaration of error.
And if ownership has changed or it's required, assign consent.
Let's dig into that oath for a second, because that seems like a potential tripwire. Can you just copy the oath or the consent from the parent reissue application?
Good question. And the answer is not necessarily. This is a point practitioners can easily overlook in the heat of the moment. If you do copy the assignee consent and the oath from the parent, the MPP says the examiner must verify that those documents still apply to the specific error you're trying to correct in this new child application.
So if the child application is addressing a totally different error than the parent was,
then the old oath or consent might not cut it. If the subsequent application, say a divisional, is tackling a brand new discrete error, one that wasn't mentioned or scorned to in the parent reissue's declaration, then yeah, you'll likely need a fresh consent and a new declaration.
let me try an example. Say the parent reissue was fixing some claim language, error A. But now you file a divisional to fix, I don't know, a defective drawing, error B.
Right.
The oath from the parent, which only talked about error A, probably wouldn't cover error B in the divisional.
That's exactly the kind of scenario. The oath has to confirm that every corrected error being pursued in the current application arose without any deceptive intention.
Duty of candor again.
Paramount. The office needs that duty reaffirmed for each distinct legal filing, even if they all spring from the same original patent.
Okay. Understanding that duty and the need for rigorous continuity, it seems like that leads us right to the examiner's main challenge here. Policing claim overlap.
Yep. Let's switch hats.
From the USPTO perspective, once that paperwork pedigree is hopefully established correctly,
Right, assuming it is.
the examiner then has to deal with potential double patenting issues, don't they?
Absolutely. When you have multiple reissue applications pending simultaneously for the same original patent, there's a really high chance you'll end up with the same or very similar claims presented in more than one place.
So if the exact same claims are pending in two parallel reissues, what does the examiner do? How do they reject that?
Two main avenues, typically. First, they might reject the claim for failure to correct an error.
Failure to correct an error. How does that apply if the claim is in the application?
Well, the examiner is basically questioning why this claim needs to be in this second application at all.
Okay. Can you give a quick scenario?
Sure. Imagine the parent reissue was filed to fix, say, claim drafting error A. During prosecution, maybe things aren't going well, so the applicant files a divisional reissue trying to pursue Claim X.
Right.
Now, if Claim X, or something very close to it, was already present or could have been presented and amended in the parent application, the examiner can argue that the error, the inability to get Claim X allowed, should have been addressed back in the parent.
I see. So filing the divisional looks less like correcting a new error.
And more like trying to get a second bite at the apple on the same subject matter, maybe with slightly different arguments. It can look like trying to abuse the process.
That really puts the focus back on reissue being strictly for correction, not just continuing prosecution indefinitely.
Exactly. The second main rejection avenue is under 35 U.S.C. Section 112 for indefiniteness.
How is having the same claim in two applications indefinite?
Because it creates uncertainty. If both applications were somehow allowed with the identical claim, which patent actually covers that subject matter, it makes the scope unclear, hence indefinite.
Right. And all this, the overlapping claims, inevitably points towards
Terminal disclaimers.
Yeah. Examiners have to raise non-statutory double patenting concerns, even if they're just provisional while applications are pending.
That's the standard tool in the toolbox. If the claims across the related reissues are found to be patentably indistinct, meaning they're obvious variants of each other, not truly separate inventions,
Then the applicant has to file a terminal disclaimer.
correct, to overcome that rejection.
And strategically, for the applicant and the public, what does that terminal disclaimer achieve?
Two really critical things from a business and public policy perspective: common ownership and common enforcement.
Okay.
By filing it, the applicant agrees that the later issued patent will expire on the same date as the earlier one, and that both patents must always be owned by the same entity.
So the public knows these related patents travel together.
Precisely. You can't have two different companies owning or enforcing patents on essentially the same invention, potentially extending the monopoly period indirectly. The terminal disclaimer prevents that.
Got it. Okay, let's talk strategy from the applicant's side. When does this whole situation needing multiple reissue applications actually come up in practice? What triggers it?
Usually one of two main scenarios based on the sources. First, divisionals. They often pop up because the examiner issues a restriction requirement.
Standard practice.
Yeah.
The examiner says, hey, you've got claims to two different inventions here. Pick one for this application.
Exactly. And that forces the applicant to split off the non-elected claims into a divisional reissue application, assuming they still want to pursue them and they qualify for reissue.
But you can also file them proactively.
Yes, under 37 CFR 1.177, applicants can choose to file a divisional reissue themselves even before the examiner forces them to.
Why would they do that? Why proactively split?
It can be tactical. If you, the applicant, know from the start that certain claims relate to a clearly distinct aspect or invention compared to others you're correcting. Filing a divisional early creates separate, parallel prosecution streams. You might get the clearer claims allowed faster in one application, while the more complex or disputed issues continue in the parent. It gives you more control over the pace.
Okay, that makes sense. And the other main scenario, continuation reissues.
Those are a bit different. They're used specifically to allow prosecution to continue on additional errors in the patent.
Errors that maybe weren't identified initially.
Right, or maybe errors that came up during the prosecution of the parent reissue but weren't fully addressed or resolved there. The continuation lets you keep pursuing those uncorrected aspects without abandoning the progress made in the parent.
Assuming, of course.
Assuming, crucially, that you properly establish that continuity link back to the parent and the original patent we discussed earlier.
It always comes back to that link.
Always.
So, wrapping up this deep dive into MPEP section 1451, what we've really seen is that correcting a patent using multiple reissues is intensely procedural.
Very much so.
The system tries to give you necessary flexibility, multiple reissues for distinct parts, but in return, it demands absolute, unambiguous clarity.
Clarity on continuity, clarity on formal compliance, the oath, the consent, and especially that vital cross-referencing language.
Right. So if we think about the big picture for you, the practitioner listening, what's the biggest risk here? Is it getting a double patenting rejection?
Probably not. Having patentably indistinct claims, that's usually manageable, right? You file a terminal disclaimer, ensure common ownership. It's a known process.
Okay. So what's the real minefield?
The true procedural minefield, the place you can really blow things up, is failing to establish that statutory bridge correctly right at the beginning.
Mishandling the initial identification,
Yep.
falling into that Bauman trap we talked about.
Exactly. Because if you do that, what's the ultimate potentially unfixable consequence?
Losing the benefit of the original patent filing date.
Bingo. And that date, as we said, affects priority, prior art, validity, term,
Yeah.
everything. Unlike a double patenting rejection you can often fix with a form, losing that effective filing date because you missed the Section 251 versus Section 120 distinction, or you just didn't put the right sentence in the spec. That's a fundamental structural error.
An error that can cripple the patent's value and enforceability later on.
Absolutely. It's a far, far harder problem to try and fix after the fact, if it's even fixable at all. The risk is just too high compared to the simple act of getting that cross-reference right.
So the final thought, prioritize that explicit cross-reference, always.
It's your legal lifeline. Don't skip it.
An excellent point to keep front of mind as you navigate these rules. The paperwork truly is the legal lifeline here.
Disclaimer. This summary of the MPEP was generated using AI tools, including ChatGPT and NotebookLM, and may contain errors or omissions. It is provided for general educational and informational purposes only and is not legal advice or a substitute for formal instruction. For authoritative guidance, consult the official MPEP, a qualified instructor, or a registered patent practitioner.